This is the Ontario Court of Justice in the matter of the applicant Mr. John Dundee versus the victim Sue Charlton for the judicial interim release hearing before the judges Jakub Kokavec, Stella Yancy, and Karina Baciu. The hearing date is 9th of June 2023. With the consent of defense counsel, allegations were read into the court by the Crown. The information set out in this introduction is primarily based on those allegations. On January 3rd, 2023, Mr. Dundee was charged with assault with a weapon, specifically a saucepan. 2 policemen were called at the scene, but none of them, in their statements, there was no mentioning of the weapon in cause, as well as the witness, Sarah Connard, failed to do so. Moreover, the witness declared that Ms. Charlton was actually the one attacking Mr. Dundee by throwing a bottle at him. The applicant has been previously charged with aggravated assault against his partner as well. Mr. Dundee was abusing illegal substances and alcohol. The defendant got accepted to a Trafalgar Residential Addiction Treatment Facility in Erin, willingly showing that he is wanting a change. The court recognizes there is a very limited amount of information regarding the introduction of the case. Neither the defense or the prosecution succeeded in providing context for the charge with assault with a weapon. This gives the court a harder time in the decision-making process. The background of the accused. John Michael Dundee was born in the 1st of November 1978 in Canada. The accused had the occupation of being a gardener. He was living together with his domestic partner, Sue Charlton, at 17 King Road in Toronto, Canada. The individuals knew each other for about 5 years, and they started a relationship soon after meeting. The applicant has also struggled in the past with drug addiction and alcoholism, specifically using the substance MDMA. Moreover, Mr. Dundee also served in Afghanistan. After he served, he was took at an administrative job in the military, but ultimately was discharged because in 2010 he was diagnosed with post-traumatic stress disorder, also known as PTSD.
The accused's criminal record was submitted by his counsel, and his convictions are as follows. In 2010, he was caught fishing without a license. In 2016, he was caught driving a motor vehicle without permit and unlicensed. In 2022, 2021, and 2019, he was caught in possession of a substance. In 2022, he caused an accident resulting in body harm and failed to stop. In 2021 and 2012, he caused nuisance in public place. In 2019, he was charged with aggravated assault and imprisoned for 9 months and breached a probation order. In 2017, he breached a conditional service order, which also happened in 2015. Again, in 2017, he operated a conveyance BAC over 80 milligrams, which also happened in 2015. And in 2015, he was caught dangerously operating a motor vehicle and failed to stop. In 2011, there was operated conveyance impaired. Mr. Michael John Dundee is charged with 3 charges on 1 information, which is before the court. He is charged with the following 3 offenses: assault, uttering threat to kill, and assault with weapon. Where in the case of the first 2 offenses dated 2nd of January, Mr. Michael John Dundee has pleaded guilty. In the case of the 3rd charge, namely assault with weapon, dated 3rd of January, Mr. Michael John Dundee has not pleaded guilty.
In this bail hearing, the onus is on Mr. Dundee due to the charging he is facing. Therefore, it is his responsibility to provide sufficient evidence based on a balance of probabilities to demonstrate why his custody is not required in light of the reasons outlined in sections 515.10 of the Criminal Code. Consequently, the court will consider all aspects related to the accused, including the plan for supervision if he is released. Proposed plan of release. The representatives of Mr. Dundee and the prosecution agree that the main plan of Mr. Dundee's release is him going to Trafalgar Addiction Center. His stay in the center for a total of 60 days begins on the 14th of June, while the decision of bail is taken today, 9th of June. The defense suggests that these 5 days, Mr. Rackman, a close friend of Dundee, who advocates for him, can possibly accommodate him. The prosecution does not make any reference on that issue. Defense does not appear to be contrary to the bail conditions imposed by the police. However, there are some objections regarding his possession of devices connecting to the internet and handing his passport in to the authorities. In addition, defense suggests that if Mr. Dundee gets released, it will be necessary to attend all the treatment appointments, despite the fact that the police disregarded this condition. Prosecution strongly supports that Mr. Dundee should not have any contact with the victim and the witness, nor with his drug dealer, whose identity is not provided. They recommend random drug and alcohol testing to the defendant, while the rehabilitation center will be required to provide reports regularly of his situation. As it concerns the period after the 60 days in the rehabilitation center, defense gives the possibility that his residence in the center can be possibly extended. On the other hand, prosecution proposed house arrest with monitoring. Analysis. Primary ground. The Criminal Code establishes the primary ground for detention as set out in paragraph 515.10a. Mr. Dundee is charged with assault with a weapon to an intimate partner. An offence involving violence against an intimate partner is considerably serious under Canadian law. The offence can be charged as an indictable or summary offence, with imprisonment can reach the maximum of 10 years. Mr. Dundee has been also charged with multiple and various offences. Currently, he is charged with an assault and uttering threat to kill with imprisonment of each crime not exceeding 5 years. In defense considers that there is a lack of evidence in the case. It points out the doubtful existence of the missing alleged weapon, the conflicting statements of Ms. Charlton, the lack of credibility of the victim, and finally the witness who did not observe any of the facts that Ms. Charlton claims that happened. Regarding the ties with the community, except the existence of the domestic partner and his close friend Steve Rackman, the court does not have any information concerning the other possible ties with the community, fact that seems problematic. In terms of his character, it can be said that he is a strong ex-soldier. However, war led him to have mental issues, struggling with PTSD. He is prone to substances, and it can be characterized as an irritable person considering his past. His willingness to enter into the rehabilitation center shows a man with will to change. Lastly, concerning the proposed release plan, the court finds it in general ground sufficient. Mr. Dundee has been struggling for a long time with his addiction, and his entrance to the rehabilitation center is a great opportunity that he has to make a new beginning. However, with regards to the 5 days gap, the court is unable to evaluate Mr. Dundee's friend. This is why we suggest he is staying in detention till the 14th of June. Regarding the specific issue of the subsequent house arrest, the court finds unclear in the prosecution arguments which house would the defendant stay in, since the previous residence of Mr. Dundee was the apartment of the victim. Therefore, the court suggests that after the 60 days, it will be a reassessment of Mr. Dundee's situation for a possible extension period in the rehabilitation center or electronic monitoring in case it will be accommodated by his friend. For these reasons, the accused met his owns of the primary ground.
In section 51510B of the Canadian Criminal Code also establishes on the secondary ground that the detention is necessary for the protection or safety of the public, including any victim of or of the witness of the offense. The court must consider whether this is a substantial likelihood that, if released, Mr. John Dundee would commit offenses putting the safety of the public at risk. The prosecution has failed to provide an argument relevant to the section. Instead, they focused on other laws which are still important but not crucial to the evaluation. Therefore, there are no comparable grounds for the court to decide on. After careful consideration, it is clear that Mr. John Dundee does not appear to have other likely paths to follow. There was evidence before this court to provide a positive social network to which he could return to. The facility that he got accepted under falls under this category. Having a spot for 60 days at the facility will significantly lower the chances of Mr. Dundee committing a similar offense. In this regard, the court agrees that the criteria under the section 51510B has not been met. However, the court is highly aware of the seriousness of the addiction, and therefore the decision is not treated lightly. As a consequence, we are left with little concerns if Mr. Dundee should be released. Although the worries are small, the court recognizes that the possibility of uncooperation from the applicant is possible, therefore certain conditions on the bail must be provided. Thus, the court is firmly on the view that the detention is not necessary, the onus has been met on the secondary grounds, and there is not a substantial likelihood that the accused will engage in a serious criminal activity if he is released.
Section 51510C of the Criminal Code sets out the tertiary ground. Based on both submissions, this court is concerned whether the defendant will re-offend if he is not kept in detention. Considering his previous offenses against the victim, this court is concerned about the possibility of the defendant harming the victim as expressed by the victim herself. However, the defendant was granted a place in the Trafalgar Rehabilitation Facility for 60 days, starting June 14th. As the defense argued, the defendant could not be released in public and stay with his friend Steve Rackman, even with electronic monitoring, and this could harm the confidence public has in the administration of justice. This court agrees that detention is necessary considering the case of the defendant until the place under the facility is available. According to both submissions discussing the strength of the prosecution's case for assault in question, there is no direct testimony from any witness confirming the use of weapon. However, there is a statement provided by the victim herself. Neither of the responding police officers saw the alleged weapon, and the witness statement by Sarah Connor is contradicting to the story of victim. Even though the witness is a minor, as confirmed by the Canada Evidence Act, all persons at the age of 14 are presumed to have capacity to testify. The prosecution argued that detention is necessary to ensure the safety of the witness. The court fails to see the relevance of this argument as the witness majorly helps the defendant's case. This court considers the principle of inconsistency in the case of the defendant. Furthermore, the circumstance surrounding the case, namely the contradicting statement by witness, victim, and police, the will to change by the defendant, prove insufficient to refuse bail. In relation to the severity of the offense and the possibility of long-term prison sentence, this court is taking into account the principle of parity and the defendant's past offenses. The maximum sentence possible for aggravated assault is 14 years and 10 years for assault with weapon. The defendant received a 9-month prison term for the offense of aggravated assault against the same victim. Therefore, this court believes that assault with weapon is less serious than the previous offense, and the possibility of a long-term imprisonment is low. For these reasons, the accused met his onus on the tertiary ground. For all the reasons given, the court orders the detention of the accused until 14th of June 2023, after which the accused will be released on bail to attend the center on the primary, secondary, and tertiary grounds, dated 9th of June 2023.